Uniform Civil Code, a promise to establish a common civil code that shall govern all citizens of the country.
परिवार के एक सदस्य के लिए एक कानून हो, परिवार के दूसरे सदस्य के लिए दूसरा कानून हो, तो क्या वो घर चल पाएगा क्या?
It must govern all secular activity.
Unconstitutional, but they are bulldozing. देश के स्वास्थ्य के लिए अच्छा नहीं.
This is in stark contradiction to what is envisaged in our constitution.
सुप्रीम कोर्ट डंडा मारती है, कह रही है कॉमन सिविल कोड लाओ.
The Uniform Civil Code has remained a distant dream. Uniform Civil Code yet again finds a place in poll promises, a promise to establish a common civil code that shall govern all citizens of the country. The underlying idea is that Hindus, Muslims, Sikhs, Christians, agnostics, atheists, Buddhists, believers, non-believers, everyone who is a citizen of this country must have a common legislation or a code that governs matters of civil conduct. For example, marriage, divorce, inheritance, adoption, succession, etc. In other words, it must govern all secular activity pertaining to a human being in the country, irrespective of that human being professing a particular faith. Presently, India has a multiverse of personal laws under which members of different religions are allowed to follow their own personal laws. In many cases, they are highly arbitrary and they erode the very concept of equality that is guaranteed by the Constitution of India. No doubt, the freedom of religion is guaranteed under Article 25 of our Constitution. But what that freedom of religion guaranteed under 25 protects is cultural diversity, and it guarantees the freedom of conscience. It is often misquoted as a barrier to the Uniform Civil Code. Let's not forget that all modern democracies across the world guarantee freedom of conscience and guarantee freedom of religion. But none of those democracies protect the application of an arbitrary personal law. For example, illustratively, applying Shariya Law and providing unequal share in the inheritance of property to a daughter as compared to a son. Cultural diversity across Europe, America, and other progressive democracies have not deterred those nations from having a common civil code. One would be surprised to know that even in the larger Indian region or the subcontinent, the northwest frontier province up to 1935 was not subject to Sharia law. Muslims followed a common set of laws along with their Hindu brothers and sisters in matters of succession and in other matters of cultural or secular significance. So much so that in 1939, the central legislature had to intervene and abrogate the application of a common set of laws to Hindus and Muslims of the Northwest Frontier Province and apply Sharia law to the Muslims. Now, this is not all. Up until 1937, in various other parts of our country, such as the United Provinces, today's Uttar Pradesh, the Central Provinces, today's Madhya Pradesh, the Bombay region, etc., Muslims to a large extent were governed by the same set of rules that were applicable to Hindus in those regions in matters of succession. Today, the integrity of our nation is threatened by the decisive forces of regionalism and communalism seeking to tear apart and destroy the nation's integrity. This is in stark contradiction to what is envisaged in our Constitution. The preamble of our Constitution specifies clearly that the Constitution secures to all Indians, that is all its citizens, fraternity, assuring dignity and unity and integrity of the nation. The directive principles enshrined in the Constitution visualizes diversity and attempts to foster uniformity amongst the people of different faiths. Further, Article 44 of our Constitution enumerates that the state, and when we mean the state, the nation, shall endeavor to secure to its citizens a uniform civil code. Now, despite all of this contained in the Constitution, the Uniform Civil Code has remained a distant dream. The Supreme Court of India, in the case of John Vellamattam, observed that the freedom of religion in Article 25 on the one hand and the necessity to bring in a uniform civil code under Article 44 on the other hand, they show that the both can coexist. That is, Article 25 and Article 44 show that the former guarantees religious freedoms, whereas the latter divests religion from the social relation and personal law. In other words, there is no need for religion to intervene in social relations amongst the people in this country. It is no matter of doubt that marriage, succession, and other matters of secular character and social relations cannot be brought within the guarantee enshrined under Article 25, that is the freedom of conscience and the freedom to profess and propagate a religion. Following the intent that the drafters of our constitution had, the Supreme Court, through a catena of decisions, has attempted to give life to the dead letter of our constitution, that is Article 44. It has observed that it is the state which is charged with the duty of securing a uniform civil code for its citizens and the country, and unquestionably it has the legislative competence to do so. Now, despite the parliament having the legislative competence to do so, the uniform civil code remains a distant dream. Now, judicial attempts batting for equality among women are many. The judgments in Shariya Law is well known, when the Supreme Court guaranteed equal rights of maintenance to Muslim women on par with their Hindu sisters. The judgment was subverted by the government of that day by bringing in a special law which removed the very edifice or the basis for the judgment. Though courts in this country have consistently and actively pushed for a uniform civil code through multitude of judgments, observations, and repeatedly sought for a timeline from the government to bring in and usher in a uniform civil code, it still remains a dream. I can't understand why anyone would fight against a uniform civil code when we have a uniform code of laws governing almost every aspect of our human relationship anyways. We have a uniform and complete criminal code which applies to all, irrespective of whether we are Hindus, Christians or Muslims, and it operates throughout the country. We have the Law on Property, the Transfer of Property Act, which deals with property relationships and which deals with interpersonal property issues, which operate throughout the country and operate irrespective of whether a person professes a particular faith or not. There are innumerable enactments in the country that can be cited to prove this point, that the country has practically a uniform civil code in all aspects. It's uniform in its content, it's uniform in its applicability to the whole of the country and to people of all faiths. The only province of law that has been able to completely stay away from this reform is marriage and succession. It is high time that there is uniformity brought on this marriage and succession issues and trappings which go around with it. Goa, for example, is a shining state which amongst all the Indian states has applied a uniform civil code regardless of religion and faith of its people. Primacy to personal law is actually a colonial baggage. It served the interests of our colonial masters, the British, in preventing integration of society and perpetuating the divide and rule policy. The colonial masters were not concerned with reform and equality at all, nor were they concerned with unity and integrity of the nation. Now, should we continue to perpetuate it? Any rule that discriminates against women will be struck down by our courts. For example, a rule that leads to pay inequality based on a gender at a workplace will be challenged, and a court of law will strike it down as being violative of the right to equality guaranteed under our constitution. Then why is it that religious courts that discriminate against women continue to survive in this country? The Uniform Civil Code would require a complete overhaul in the sphere of personal laws. It would require dozens of legislations to be re-examined, some of them repealed, and fresh codes to be brought into being which is acceptable to all commodities. This task certainly requires wide consultation and active participation of the state and the other governments of the region as well. In a federal polity, to take everyone together is important. For example, illustratively, the 6th schedule to the Indian Constitution grants and protects certain land rights of tribals and indigenous communities. Even this needs to be harmonized when you are applying a uniform civil code. The task, however, squarely lies in the domain of the legislature. The idea of a uniform civil code, which forms part of the directive principles of state policy, must not be framed as one thwarting the freedom of religion in this country. It should rather be about seeking equality for our people across religions and across communities. It must be predicated on equality and dignity and not predicated on erosion of faith. An important byproduct of the Uniform Civil Code will certainly be national integration.